Good evening, everyone. I welcome each one of you to our AOR Aspirants Academy. Today is our 18th lecture series. Because of your immense support, we are growing day by day. So I must congratulate each one of you for its massive success. Today we have gathered to discuss about scope of special leave petition. Before going to the topic, it is our everyday routine practice that we recite preamble of the Constitution of India, because we strongly believe that the entire spirit of the Constitution is reflected in the preamble of the Constitution. So the goal is there in the preamble. So therefore, I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Dear friends, it is my humble request. Every day we must ask ourselves, what is our effort to reach these goals? When we start asking these questions, we can land up somewhere in a better growth. Therefore, the Indians, the Dr. B.R. Ambedkar has said, firstly we are Indians and lastly we are Indians. So the preamble unites everyone. Now moving on to the topic, that is special leave petition. How am I going to deal with this topic? Already we have delivered 2 lectures on special leave petition. Firstly on introduction. Secondly, with respect to scope of interference of Honorable Supreme Court under Article 136. Now let me give a brief background about what was 136. What is 136 about? Article 136 of the Constitution of India. It has 2 clauses, Clause 1 and Clause 2. Clause 1 says, notwithstanding anything contained in this chapter. This chapter means that is chapter 4, that is Union Judiciary. So notwithstanding anything contained in this chapter, the Supreme Court may in its discretion grant leave to appeal against any order, any judgment, order, decree, sentence passed by any court or tribunal in any cause or matter within the territory of India. So meaning thereby, it is not an appeal to the Supreme Court from the High Court, or it is not an appeal to the Supreme Court from the final judgment. So it can be final judgment, it can be a degree also, it can be a determination also, sentence also, order also. Order may be an interim order or a final order also, passed by any court or tribunal. It may be a district court also, it may be a high court also, it may be a tribunal also. So therefore such a wide discretionary power vested with the Honorable Supreme Court of India. Now what is Clause 2 says? Clause 2 of Article 136. Under Clause 2, they say this Clause 1 does not apply to any judgment, order, degree, not degree, order, sentence passed by any court or tribunal, relating to armed forces. So when there is an armed forces order, then means it will not be applicable. SLP will not be applicable. So therefore, dear friends, under clause 1 and clause 2, it gives entire SLP. What is it all about? The powers. No problem. No problem. So these are the two provisions under Article 136, dear friends. It is a wide discretionary power vested with the Honorable Supreme Court. Why it is a wide discretionary power? Reason is any aggrieved person can appeal to the Supreme Court against any order. It may be an interim order also. Maybe passed by district court, he can come directly to the Supreme Court. So therefore, such wide power vested with the Honorable Supreme Court. So when wide discretion is vested with the Honorable Supreme Court, whether it has to be exercised generally or in exceptional circumstances, there is no restrictions found in the Article 136. Article 136 is very clear. But where do we get these limitations? That limitations means where the Honorable Supreme Court will not interfere with the concurrent findings of the facts. Generally, the Honorable Supreme Court will not interfere with the interim orders. Generally, the Honorable Supreme Court will not interfere with the discretion exercised by the courts below while imposing sentence or orders. So where do we get all this? We get all these restrictions by virtue of the judgments passed by the Honorable Supreme Court, that the Honorable Supreme Court itself has imposed self-restrictions, that this wide power cannot be exercised. It has to be exercised sparingly only under exceptional circumstances, right? And when we talk about the wide powers of the Honorable Supreme Court, the Honorable Supreme Court in one of its judgment, they have said, when the Supreme Court is chasing the injustice, the sky is the limit. The power of the Honorable Supreme Court, while chasing the injustice, the power is unlimited. Because the Honorable Supreme Court wanted to uphold justice. That is most important. The entire system is existing only to provide justice to the litigants or the public at large. So when such a wide discretionary powers, but it is limited and they will exercise only under exceptional circumstances. So what are those exceptional circumstances? So we have to ask ourselves these questions. What are those exceptional circumstances under which the Honorable Supreme Court will interfere under Article 136? On the last occasion, I have dealt with this topic under 5 headings, dear friends. The first illustration that I gave, that in the absence of speaking order, when a litigant is challenging an order before the Honorable Supreme Court of India, he has to challenge it on certain grounds. One of the grounds was when the order passed by either by the High Court or by the trial court is not supported with any reasons, no justified reasons at all. That means it is an absence of speaking order. Therefore, the Honorable Supreme Court can interfere. The reason is, why should we expect every order should be supported with reasons? That is the next question I am asking myself. The answer is, when an order, when authority is bound to give any reasons, that means it will prevent the arbitrariness. It will prevent the arbitrariness on the authority. It will prevent the authority from exercising any bias if they have towards the matter. Biasness is prevented, arbitrariness is prevented. Then justice should not only be done but also appear to be done. So these are the reasons. Even a losing litigant, if he is losing his case, but when he is reading the entire order, if it is supported with reasons, at least he will have the satisfaction that he has placed all the materials before the Honorable Court and everything got recorded and everything is well appreciated, and then they have come to the conclusion. Therefore, even a losing party will, according to him, it will found reasonable and sensible. That is the reason for giving reasons to the orders. Number 2 heading was when they can interfere with the concurrent findings of the facts. When two courts giving a finding, when the Honorable Supreme Court can interfere under Article 136. They can interfere when there is a perversity. This term I request our esteemed friends to remember this term, perversity. What is perversity? Even when we attend the courts also, when we are arguing a case before the Honorable Supreme Court under Article 136, the Honorable Supreme Court posed a question to an advocate by saying, what is the perversity that you find in the High Court order? So what is perversity? Perversity is improper reception or rejection of the vital evidence or the documents. So when there are vital documents, that is to be considered by the courts below, and they should reach the correct conclusion. If the vital documents are not taken into consideration, which they are supposed to take into consideration, or irrelevant materials are taken into consideration and they have passed the order. So therefore, on improper reception or improper rejection, that is what the perversity is. And when there is a substantial miscarriage of justice, when there is a substantial miscarriage of justice, the Honorable Supreme Court can interfere with the concurrent findings of the facts. So these were the two headings dealt in detail with the supporting landmark judgments. Now we are coming to the scope, further interference. So what are the interferences of the Honorable Supreme Court in other circumstances? Now I am going to give you three headings, dear friends, and I will be dealing it in detail. The first heading is, the third illustration rather, when Supreme Court will interfere. Please note down, when Supreme Court will interfere with the exercise of discretion of courts below while imposing sentence or fine. When the courts below have exercised their discretion and imposed a sentence or fine, generally what is the general practice of the Honorable Supreme Court is they will not interfere, because it is a discretionary power exercised by the courts below. The Honorable Supreme Court will not interfere, but in certain peculiar situations they will interfere. When? That I will be dealing with it. The next heading is interference of Honorable Supreme Court with the interlocutory orders passed by the courts below. When the interim orders, when it is challenged before the Supreme Court, when the Supreme Court will interfere with the interim orders passed by the courts below. Third heading is interference under Article 136, where questions of law and facts are involved. Where interference under Article 136, where mixed questions of law and facts are involved. So these are the three headings where we will be dealing in detail today. Hope it's clear. The first heading is interference of Honorable Supreme Court with respect to the discretion exercised by the courts below while imposing sentence or fine. Then interference with interlocutory orders. Thereafter, the third heading is interference under Article 136, where mixed questions of facts and law are involved. So these are the three headings. See, I would like to give a very, very important judgment in the matter of sentence or fine. In the matter of sentence or fine, though nothing prevents the Supreme Court from interfering with the sentence or fine imposed by the lower courts or courts below, it does not easily do so. As a matter of practice, the Supreme Court does not grant special leave where the question is only one of excessive sentence or fine by the courts below, but if the facts and circumstances of a case justify, it may interfere. So from this, what we can understand is, generally the general rule, the Honorable Supreme Court will not interfere with the discretion exercised by the courts below when they were imposing sentence or fine. This is the general practice of the Honorable Supreme Court. But the exception is, what is the exception? The exception is when they can interfere. So, for the exceptional case, I am going to refer one case, dear friends. This is Adam G. Umar Dalal. Adam G. ADAMJI, Adam G. Umar Dalal versus State of Bombay. I repeat, dear friends, Adam G. Umar Dalal versus State of Bombay. It is reported in 1952. Supreme Court reports SCR 172. Page number is 172. 1952 SCR, page number 172. Adam G. Umar Dalal versus State of Bombay, comprising of 3 honorable judges. This judgment was delivered by a combination of honorable 3 judges: Honorable Justice Syed Fazil Ali, Honorable Justice Meherchand Mahajan, Honorable Justice Vivian Bose. In this case, what happened? Here, the accused, the appellants, they have involved in black marketing of kerosene. Black marketing is illegal. So therefore, the courts below, they have given a concurrent finding, both the High Court and then the lower court also, that he should be punished. So 6 months rigorous imprisonment was given. Apart from that, they imposed 15,000 as penalty, as a fine. It was in the year 1952, dear friends. 15,000 was imposed. So these accused preferred an appeal before the Honorable Supreme Court. They are aggrieved, because already they need to undergo 6 months rigorous imprisonment plus this fine rupees of 15,000. They are aggrieved. They are coming before the Honorable Supreme Court and they are placing the arguments. My lords, we are not the principal. We are only the agents. So principal receives so much amount, but we are the agent. We don't receive that much. So therefore, 15,000 is very, very expensive and harsh. Therefore, please reduce it. So the Honorable Supreme Court consideration was, what was the issue before the Honorable Supreme Court? Generally, they do not interfere with the imposition of fine, but under what circumstances that they will interfere? So the Honorable Supreme Court has said, though substantial sentence has been imposed, that is 6 months rigorous imprisonment, fine should be imposed only with proportionate to the offence, not disproportionate to the offence. Therefore, 15,000 is too harsh and very, very a heavy fine. Therefore, it can be reduced from rupees 15,000 to rupees 1,000 rupees. So generally what we have seen, general procedure is the Honorable Supreme Court will not interfere with the discretion exercised by the courts below by imposing the fine of rupees 15,000. But in this case, the Honorable Supreme Court has reduced the fine from rupees 15,000 to rupees 1,000. So why they have reduced it? What was the principles evolved in this case when the Honorable Supreme Court exercising in exceptional circumstances? So they are asking the question, the determination of the right measure of punishment is often a point of great difficulty. Dear friends, as a lawyer, we can argue the case and ultimately we will leave it to the lordships. But authority, one who has to decide who is right and who is wrong, it is a very, very important role. That is why we say it's a divine role. It's a delegated power of Almighty to the lordships. So it becomes very difficult to determine who is right, who is wrong. Even if we determine that he is a guilty person, how much punishment can be imposed? That is a very difficult job. They are asking themselves the question, the determination of the right measure of punishment is often a point of great difficulty, and no hard and fast rule can be laid down, it being a matter of discretion which is to be guided by a variety of considerations. This we have to, it differs from case to case, and while imposing punishment we have to consider many factors into consideration, but the court has always to bear in mind. So this is what the principle, dear friends, what the court has always to bear in mind: the necessity of proportion between an offense and the penalty. When you are imposing penalty of rupees 15,000, whether does it proportionate to the offense committed or is it disproportionate? That is the principle. Here, in imposing a fine, it is necessary to have as much regard to the pecuniary circumstances of the accused persons. So you cannot ask a person to pay 1 crore rupee where he is not able to have his breakfast or lunch. Therefore, it becomes impossible, unworkable order. So you have to impose the penalty based on the payability of the litigant. So pecuniary circumstances of the accused persons as to the character and magnitude of the offense, and where a substantial term of imprisonment is inflicted. Here 6 months imprisonment is already given. Where a substantial term of imprisonment is inflicted, an excessive fine should not accompany it, except in exceptional cases. Further, though they are saying, though the offense of black marketing is very generally prevalent in the country, they are talking about in the year 1952, though the offense of black marketing is very generally prevalent in this country and at the present moment, and when it is brought home against a person, no leniency in the matter of sentence should be shown, and a certain amount of severity may be very appropriate and even called for. Yet, when a substantial sentence of imprisonment has been awarded, especially to a commission agent, not the principal, here commission agent, imposition of unduly heavy fines which may have been justified to some extent in case of principal. When it is for the principal, it is something different. Here it is only an agent. So therefore, it is not called for. It is not the practice, dear friends. Here they are telling about the general practice of the Honorable Supreme Court. It is not the practice of the Supreme Court to interfere by special leave in the matter of punishment imposed for crimes committed, except in exceptional cases where the sentences are, this is very, very important. Reason is they are culling out the exceptional situations. The exceptional circumstances are where the sentences are unduly harsh. Number one ground under which the Honorable Supreme Court will interfere, that is unduly harsh and do not really advance the ends of justice, and do not really advance the ends of justice. These are the two grounds under which the Honorable Supreme Court can interfere: unduly harsh and do not really advance the ends of justice. The court interfered in these cases and reduced the sentences on the ground that the fines were imposed were very heavy and quite disproportionate to the offences. In this case, I just wanted to highlight one point where the courts below, that is presidency magistrate, when he was imposing 15,000 rupees, what was the finding of the magistrate? The learned presidency magistrate, while imposing the sentence, he observed as follows. This is very crucial, dear friends. Magistrate observing in these lines: such black market transactions, when detected, must be crushed, else the common man has no escape from the plague. So he is calling it as a plague, and common man cannot escape from this plague. Therefore, once black marketing is found, it has to be crushed. Therefore, he imposed 6 months rigorous imprisonment as well as 15,000 rupees. Now, the Honorable Supreme Court has reduced to rupees 1,000 from rupees 15,000. So this is one such circumstances where the Honorable Supreme Court can interfere even with the discretionary power exercised by the courts below while imposing sentence. Hope it's clear. Now moving on to the next case. This is Lalit Mohan Das. Lalit Mohan Das versus Advocate General Orissa. Lalit Mohan Das versus Advocate General Orissa. It is reported in 1957 Supreme Court report, page number 167. 1957 Supreme Court report SCR, page number 167. This is a combination of 5 judges, dear friends. This is a constitution bench judgment. Who are all the honorable judges? Honorable Justice S.R. Das, Chief Justice. Honorable Justice Bhagwati. Honorable Justice Venkatrama Iyer. Honorable Justice B.P. Sinha. And Honorable Justice S.K. Das. In this case, what has happened? Lalit Mohan Das was a pleader. He was an advocate practicing in a municipal court. What did he say? He was practicing in the municipal court. Dear friends, please, I will narrate the facts and then I will read out the relevant points. Lalit Mohan Das, he was practicing in a municipal court. He had a strained relationship with the judge, municipal judge. In open court, Mr. Lalit Mohan Das has said to municipal judge by saying, you are not fair. You are not fair and you are very partial. So these two things he uttered in the open court. Honorable judge found that it is not suitable, that these comments are not fit to a pleader. That too in the open court, it would amount to scandalizing the court. So therefore, he initiated a proceedings under Legal Practitioners Act and he submitted a report to the Honorable High Court through district judge. So in the report, his opinion is also accompanied. So in this case, what has happened? The Honorable High Court, the Honorable ADJ, Additional District Judge, wanted to resolve this issue. So they have suggested 2 things to the pleader, that is Lalit Mohan Das. First, write an apology letter. Accept your mistake, that you will not repeat it. Secondly, there should be a resolution passed by the association. So he wrote an apology letter. That was based on his apology letter, it was closed. Matter was closed. Thereafter, the judges had come to know that second condition, that resolution was not passed by the association. They have reopened it. Inquiry started. And the Honorable High Court, when they received the opinion or the report, the municipal judge has given his opinion that that advocate, his period of practice must be suspended to 1 year. So his practice should be suspended for 1 year. That was an opinion given by the municipal judge. But the Honorable High Court has suspended his practice for 5 years. Now, Mr. Lalit Mohan Das was aggrieved. He came before the Honorable Supreme Court. The Honorable Supreme Court, what is the general practice? The general practice is they will not interfere when there is a discretionary power exercised by the courts below. That is, Honorable High Court has exercised its discretionary power and suspended his practice for 5 years. But in this peculiar circumstances, the Honorable Supreme Court has considered few peculiar factors. Firstly, he gave an apology letter. Therefore, he has accepted his mistake and he has assured that it will not be repeated. That is number one factor. Number two, the Munsif judge, at whose instance the entire disciplinary proceedings started, he himself gave an opinion that he has to be suspended only for 1 year. But when the matter reached the Honorable Supreme Court, Supreme Court, he had already undergone suspension almost for 1 year and 8 months. So the Honorable Supreme Court felt 5 years is too harsh, therefore let us reduce it to 2 years. So it was reduced from 5 years to 2 years. So in this judgment, though the Honorable Supreme Court has exercised discretionary power and suspended his practice for 5 years, in exceptional circumstances, the Honorable Supreme Court reduced from 5 years to 2 years. So what are the important factors? How they have dealt with? What is the duty of the advocate towards the client also, as well as towards the court also? Because he is not only a mouthpiece of the client, but also an officer of the court. So let me read, dear friends, the important portions. The appellant pleader, Lalit Mohan Das, who already had strained relation with the Munsif, made certain objectionable remarks in open court, suggesting partiality and unfairness on the part of the Munsif. The Munsif drew up a proceedings under sections 13, 14 of the Legal Practitioners Act 1879 against the pleader and submitted a report to the High Court through the district judge. The additional district judge made an effort to settle the trouble. It was arranged that the pleader should apologize and a resolution should be passed by the member of the local bar association. Accordingly, the pleader appeared in the court of the Munsif and filed a written apology and expressed his regret, and the Munsif dropped the proceedings. It was later found that the resolution was not passed in the terms suggested by the additional district judge, and the terms of settlement suggested by the latter were not fully carried out. Accordingly, the proceedings was reopened and the report was resubmitted to the district judge, who with his opinion forwarded the same to the High Court. The High Court suspended the pleader for 5 years. It was contended on behalf of the appellant. Now, matter is before the Honorable Supreme Court. Now, what is their contention before the Honorable Supreme Court? It was contended on behalf of the appellant that there was no valid reason for reviving the proceeding after it had once been dropped on the submission of an apology and expression of regret. It was held by the Honorable Supreme Court that the report under Section 14 of the Legal Practitioners Act is a report which is to be submitted to the High Court. When a report is made to the High Court by any civil judge subordinate to the district judge, the report shall be made through the district judge and the report must be accompanied by the opinion of such judge. Once the report has been made, it is not open to the district judge to send back the record to the subordinate civil judge, and no order passed by the subordinate civil judge can have the effect of terminating or bringing to end the proceeding. The High Court alone is competent to pass final orders on the report. A member of the bar is an officer of the court. Dear friends, this is very, very important because one of the subjects in the AOR examination is professional ethics. And one of the subjects, that is professional ethics, is also there for the law students. And it is not mere reading and securing marks. It is our everyday practice. So whenever we are appearing before the court, we must follow the dress code and we must always remain as a gentleman inside also as well as outside the court also. Because the common man, layman will get angry, he may get frustrated, he may get irritated, but we, the educated people, we should know how to control our anger, how to react. So everything, when we observe very keenly, And when we apply our mind very carefully, then we can solve any issues. So therefore, dear friends, mind is most important. That's why they say mind should be divine. Mind should always have a thinking where how to progress ourselves, how to upbring others, how to uplift others. When we ask these questions in our mind, definitely it will find its own way. If you are going to ask wrong question to the mind, it will take you to the wrong path. So therefore, mind may be a good or the best friend, or it may turn out to be the worst enemy. Whether you want to treat it as your good friend or the worst enemy, it is in our hands, dear friends. So therefore, a member of the bar is an officer of the court, and though he owe a duty to his client, must place before the court all that can fairly and reasonably be submitted on behalf of his client. He also owe a duty to the court and must uphold the dignity and decorum of the court in which he is appearing. So he must maintain the dignity and decorum of the court, because we say in a temple of justice, lords are the deity and we are the priest. Making imputations of partiality and unfairness against the subordinate civil judge in open court is scandalizing the court in such a way as to pollute the very fount of justice. Such conduct is not a matter between an individual member of the bar and a member of the judicial service. When you make some imputations to a particular judge, it is not a dispute between a member of the bar and a particular judge. That means we are questioning the entire system. So you are throwing a stone on the third pillar of the democracy. So therefore, we must always maintain the dignity and decorum of the court. Though we may lose our cases, but we should not lose our temper. Right? Losing cases depends upon the merits and demerits of the case. When we go to a juice shop, when we order for a fresh apple juice, but he prepares a juice out of the rotten apple, we can return it. If it is a good apple, we will get a good juice. Likewise, if it is a good merits, then we will get a good order. When there is no merit at all, then we may lose the case also. It depends upon not only on the part of the advocate, but also what is the case that he brings. Whether he brings a good apple or good case, whether it has a merits on it, that also matters a lot. So therefore, dear friends, when we win or lose the case, it not only that we are not the solely responsible. It depends upon the matter, it depends upon the judge, and how we have prepared, how other side has prepared. It matters a lot. So therefore, whatever it is in our hands, we must praise it effectively and sincerely. So with regard to the disciplinary action against a member of the bar, the Supreme Court would be reluctant to interfere with the order of the High Court unless there are mitigating circumstances. What they are saying is, the Honorable Supreme Court has held, we will not interfere with the High Court order unless and until it is shown that there are mitigating circumstances. What are the mitigating circumstances? What circumstances under which this sentence can be reduced? According to the Honorable Judges, they have reduced the sentence from 5 years to 2 years on 2 grounds, dear friends. What are those 2 grounds? The Honorable Supreme Court has found there are 2 mitigating circumstances. One is that the learned Munsif himself recommended suspension of practice for 1 year only. Number 1. The appellant was suspended from practice with the effect from March 15, 1955. The order of suspension has now lasted for a little more than a year and 8 months. This is number 1 mitigating circumstances. The second mitigating circumstance is that appellant did file a written apology and expressed regret to the learned Munsif on January 8, 1954. It is unfortunate that the appellant did not take up a more concrete attitude in the High Court. In this court, the appellant tried to make out the proceedings against him should not have been revived. He, however, showed his willingness to offer an apology and expression of regret. Having regard to all the circumstances, we think that the punishment imposed errs on the side of excess. We would accordingly reduce the period of suspension to 2 years only. In the result, the petition under Article 32 is dismissed and the appeal is also dismissed, subject to the reduction of the period of suspension as indicated above. In the circumstances of the case, there will be no order for cost. So we have found two mitigating circumstances under which it has been reduced. Now moving on to the third case, Pandurang Tukia and Bilia. These are all name of the accused. Pandurang, Tukia and Bilia versus the state of Hyderabad. It was comprising of 3 judges, dear friends. Pandurang versus the state of Hyderabad. Pandurang, Tukia and Bilia, or you can write Pandurang and others versus the state of Hyderabad. It is a combination of Honorable 3 judges, Honorable Justice Mukherjee, Honorable Justice S.R. Das and Honorable Justice Vivian Bose. In this case, where the death sentence was reduced to, citation is 1955, Volume 1 SCR.
State of Hyderabad or Andhra?
State of Hyderabad. 1955, Volume 1 Supreme Court Report, page number 1083. So in this case, dear friends, the Honorable Supreme Court has reduced the sentence from death sentence to life. Why they have reduced it? They have reduced it because though they have found, the Honorable High Court have found them guilty for murdering a person. But after finding them guilty, the 2 judges of the Honorable High Court has differed between themselves on the quantum. One was favoring for death sentence and one was not in favor of the death sentence. So when 2 judges are differing on the quantum of the sentence, it is obvious that it has to be reduced from the death sentence to the life sentence. This is what the Honorable Supreme Court has held in this case. So generally, the general practice is the Honorable Supreme Court will not interfere with the discretion exercised by the High Court while imposing sentence, be it death sentence or life sentence. But in this case, the Honorable judges themselves differed on the quantum of the sentence. One says death sentence, another judge says life sentence. Therefore, this itself a good ground to interfere. So the Honorable Supreme Court has reduced the death sentence to life sentence. In this case, dear friends, they have beautifully discussed about what is common intention, section 34. What is similar intention? What is common intention? And beautifully they have discussed. I will narrate now. It is well settled that common intention is section 34 of the Indian Penal Code presupposes prior consent. Prior consent means prior agreement, whether they had planned together, they had any consensus ad idem before that. It requires a pre-arranged plan because before a man can be vicariously convicted for the criminal act of another, the act must have been done in furtherance of the common intention of them all. Dear friends, this is a classic case for section 34 of IPC. Reason is because when 2 accused or 3 accused are involved, one accused might have given a fatal blow. Because of the fatal blow, he must have died. But another person, he was a mere spectator. But he will also be trapped and he will also be brought by invoking section 34 of the IPC that there was a common intention. So to prove that there was a common intention or not, this judgment will help us how to distinguish between the common intention and the similar intention. They are beautifully discussed. So it requires a pre-arranged plan because before a man can be vicariously convicted for the criminal act of another, the act must have been done in furtherance of the common intention of them all. Accordingly, there must have been a prior meeting of minds. If they are going to commit an offense tomorrow, they should have met, or they must have had a pre-arranged plan. Prior meeting of minds. Several persons can simultaneously attack a man, and each can have the same intention, namely the intention to kill, and each can individually inflict a separate fatal blow, and yet none would have the common intention required by this section because there was no prior meeting of minds to form a pre-arranged plan. What they are saying here is, for example, 10 persons attacking and they want to kill one person, but individually one person is an enemy to all 10, but all 10 they never had a pre-arranged plan, no meeting of minds. Everybody has planned in separately, individually to attack a particular, say A. So these 10 people, though they have a intention to kill him, but they never share the common intention because no prior meeting of minds. Several persons can simultaneously attack a man and each can have the same intention, namely the intention to kill, and each can individually inflict a separate fatal blow, and yet none would have the common intention required a pre-arranged plan. In a case like that, each would be individually liable for whatever injury he caused, but none could be vicariously convicted for the act of any of the others. And if the prosecution cannot prove that a separate blow was a fatal one, he cannot be convicted of the murder, however clearly an intention to kill could be proved in his case. So care must be taken not to confuse same or similar intention with common intention. Same intentions, 10 people individually have an intention to kill that particular A, but never they had the common intention because there was no prior meeting of minds from 1 to 10. So the partition which divides their bounds is very often very thin. Nevertheless, the distinction is real and substantial, and if overlooked will result in miscarriage of justice. The plan, so now they are talking about how the plan has to be, whether they need to have a master plan for 10 days or 20 days, or how the plan has to be. The plan need not be elaborate, nor is a long interval of time required. It could arise and be formed suddenly. So the same common intention, it could arise and be formed suddenly, but there must be. So what is necessary is, it is not material that how much time they took for the plan, but what is material is that pre-arrangement and premeditated concert, that is agreement. It is not enough to have the same intention independently of each other. So the inference of common intention should never be reached unless it is a necessary inference deducible from the circumstances of the case. It is a question of fact in every case, and however similar the circumstances, facts in one case cannot be used as a precedent to determine the conclusion on the facts in another. Dear friends, in criminal law generally, the precedents will not be, the principles may be applied, but that principles has to be applied from case to case. You cannot say in this situation the lordships has given life sentence or is reduced to 10 years, therefore you should do that. Reason is facts of the case is always different. That is what the Honorable Supreme Court is holding here. It is a question of fact in every case. However similar the circumstances, facts in one case cannot be used as a precedent to determine the conclusion on the facts in another. All that is necessary is either to have direct proof of prior consent or proof of circumstances which necessarily lead to that inference, or in other words, the incriminating facts must be incompatible with the innocence of the accused. So whatever they have collected, the materials which goes against the accused, it should be incompatible with the innocence of the accused, meaning thereby it should always prove their guilt, because the law presumes that he is innocent, but incriminating materials are not coming to the conclusion of the innocence of the accused. On the contrary, it proves his guilt and incapable of explanation on any other reasonable hypothesis. If we apply our mind, there cannot be any reasonable hypothesis except coming to the conclusion that this person has murdered. If the honorable court comes to the conclusion whether A has murdered or B has murdered, if there is a doubt, then they may acquit him on the ground of benefit of doubt. But there is no reasonable hypothesis where, and then self-incriminating evidence or the facts is incompatible with the innocence of the accused, meaning thereby it is compatible with the guilt of the accused. So when such being the position, when appellate judges who agree on the question of guilt, this is very important, dear friends. When appellate judges who agree on the question of guilt differ on that of sentence, it is usual not to impose the death penalty unless there are compelling circumstances. So the final concluding para is, when the appellate judges who agree on the question of guilt differ on that of sentence, it is usual not to impose the death penalty unless there are compelling reasons. That is rarest of rare cases. We see no reason to depart from this practice in this case, and so reduce the sentence of death in the case of filia tukia to transportation for life because of the difference of opinion in the High Court. So after reading everything, dear friends, the message is this: when the Honorable High Court judges, they themselves concurred with the guilt of the accused but differed with the quantum of sentence, therefore death sentence cannot be imposed. It was reduced to the life sentence. Then one more case, dear friends. That's all. This is a one-page judgment here. That's all. Just 2 lines here. One-page judgment, but the principles are evolved in this judgment. Surendra and others versus State of Uttar Pradesh. Surendra and others versus State of Uttar Pradesh. It is reported in 1976, Volume 4, Supreme Court Cases, page number 232. I repeat, 1976, Volume 4, Supreme Court Cases, 232, page number. This judgment was rendered by the Honorable 2 judges, Honorable Justice P.N. Bhagwati and Honorable Justice S. Murtaza Fazal Ali. These are the 2 honorable judges. How beautifully they have evolved the principle when they can interfere, when the Honorable Supreme Court cannot interfere in one-page judgment. Let me directly go to the principles, dear friends. The imposition of sentence, every words are very, very important, dear friends. Therefore, I am going very slowly. The imposition of sentence is always a matter of discretion. The imposition of sentence is always a matter of discretion, and unless the Supreme Court finds that the discretion has been exercised, now they are coming to the exceptional situations. What are those exceptional situations? Unless the Supreme Court finds that the discretion has been exercised, 1, arbitrarily or capriciously, meaning thereby arbitrarily or capriciously means without giving any reasons. A judgment supported with no reasons, that is absence of speaking order, or on unsound principles. What is that unsound principles? Perversity. improper reception or rejection, or that the Sessions Court or the High Court has not taken into any relevant factors. Just now we have seen Lalit, Mr. Case, where the mitigating circumstances, where Munsif himself has given an opinion only for 1 year sentence, borrowing from practice, and he himself given an apology letter. These are the mitigating circumstances. So therefore, or that the Sessions Court or the High Court has not taken into account any relevant factors in imposing the sentence, it would not be justified in reducing the sentence. So generally the Supreme Court will not interfere with the discretionary power exercised by the courts below while imposing sentence or fine, but the Honorable Supreme Court will interfere only under exception circumstances, when the order is arbitrary or capriciously passed, or on unsound principles, or the Sessions Court or the High Court has not taken into any account of the relevant factors in imposing the sentence. So these are the 4 major grounds. It would not be justified in reducing the sentence. Now they are making a caution also, note of caution. It would not be justified in reducing the sentence merely because it feels that a lesser sentence might have been imposed. For example, the Honorable Supreme Court, if they feel that instead of death sentence, it must have been the life sentence, if they feel they cannot reduce it, mere feeling of the Supreme Court, they will not exercise under Article 136 to reduce the sentence unless and until these major factors are attracted. These are the compelling situations or the exception circumstances under which the Honorable Supreme Court will interfere. Dear friends, now let me sum up. Today we were in a position to complete only on with respect to the when the Honorable Supreme Court can interfere with the order passed by the courts below when they exercise their discretionary power while imposing sentence or fine. So we have seen these judgments. So whenever the question comes in our AOR examination paper, so depending upon what is the mark allocated, you have to write it. If it is for 15 marks or 20 marks, you can write it in detail. If it is for 5 marks, then you can summarize the principles alone. So therefore, let me sum up, dear friends. So we are seeing the Article 136 in detail. Previously, we delivered our lecture on introduction of SLP. Secondly, we have said it is a discretionary power, therefore it has exercise of the power must be sparingly exercised by the Honorable Supreme Court. Only under exception circumstances the Honorable Supreme Court can exercise under 136, because it is not a matter of right, it is a matter of discretion vested with the Honorable Supreme Court. In one of the cases where the matter was before Honorable Justice Rohinton Nariman, my lord, when a matter was called out and argued before my lord, the justice has said, though we find that there are errors in the High Court, but still under Article 136 we will not interfere. So because it is a discretionary power vested with the Honorable Supreme Court. So when these are the discretionary powers, when they can exercise, when the courts below order is a non-speaking order, though when they give the findings of fact, concurrent findings, but if it is perverse, they can interfere. Even in the discretionary power, when the courts below has imposed sentence or fine, we have seen when they have Honorable Supreme Court has interfered. In the coming sessions, we will be covering the next topics, dear friends. Thank you for your patience hearing. Thank you so much. Thank you.